Competition 2020. It is an honor to have the gracious presence of Sri Ashok Das, Senior Advocate of Odisha High Court, Sri Sonia Sundar Das, Senior Advocate of Odisha High Court, and Sri Gautam Mukherjee, Senior Advocate of Odisha High Court, on this occasion. Your Lordship, this is the petitioner side and this is the respondent side. With the permission of this court, we would like to proceed the proceedings. Of the CRP. In the present case, the council has claimed two issues. The first issue shall be dealt at the council, and the next issue shall be dealt by the co-council. The council is in commission concerning the statement of facts. Much obliged to Lordship, Odisha is one of the states in the Union of India, and in Odisha, a world famous temple that is Mohapatra temple is situated in the eastern part. Not only can we stay in the country, from all over the country, from all over the world, around 50 million people come to this place, the world famous Madhusudan temple, which is held every year in Mohapatra. The government of Odisha has launched Mohapatra Corridor Heritage Project with an investment of 3,200 crores with an aim of redeveloping and revamping the vicinity of the temple. The work was vested on Tata Project Private Limited and the project includes the establishment of cloakroom, mini cloakroom, toilets for male, female, and sebayas, and shelter pavilion, etc. With a distance of 80 meters from the temple, on 14th of October 2022, the company started installation and construction work events of which public started protesting. A PA was filed by an NGO, Assisting Foundation Trust, before this Honorable High Court, challenging the legality of the construction, and it is also contended that the use of heavy machinery in the temple would affect the very structure of the temple. It was contended that it's for the larger public interest. It was contended by the government of Odisha that it is for the larger public interest, and these are basic conditions for their sake of convenience. On the very same day, this Honorable High Court passed a status quo order and military measure based on final disposal of the TI. After the order of the status quo, when the construction work was still going on, the members of the NGO and other public started protesting, and one of the persons named Kumar out of rage broke the metal barricades of police and started laws against it under section 146, 148, 149, 152, 186, 294, 353, 427, and 506 of the Indian Criminal Code. Agreed by the same, the Rama Sabha has filed a petition under section 482 of CRPC to cause the state fire and execute the status quo order. The Tamil Region Limited has filed a petition to vacate the status quo order. The Honorable High Court has clubbed all the matters for the sake of convenience and is still there for final hearing on 19th of November 2020. The Council Commission to proceed with the argument advance. Much obliged, Lordship. In innumerable cases, it has been observed that when a court considers the application whether to grant injunction or to refuse to grant injunction, normally four things are taken into consideration. Number one, whether a primary case has been made out or not. Number two, whether the balance of convenience is in the favor of the plaintiff or not. Number three, whether it would cause irreparable injuries to the petitioner or not. Number four, the conduct of the parties. Coming to the first principle, your lordship, whether a primary case has been made out or not, in your lordship, a primary case has been made out in the instant case. Because of the following reason, since it has been already admitted fact, the company started excavation and construction work within 8 kilometers of the temple. But the same is the violation of the ancient monuments and archaeological sites in the by 1950 because section 28 of the same act provides that within 100 meters of the temple that should be that will be declared as forbidden area and no construction will be allowed within that area. And in subsection 4 of the same section 28, it has been clearly mentioned in lordship, no permission referring subsection 3, including carrying out any public work or project essential to the public or other construction, shall be granted if any forbidden area on and after the day on which the ancient monument and archaeological sites are given amendment and validation will be possible if it seems the answer of the question. In the instant case, since the excavation and the construction was carried out within 80 meters of the temple, it is clear violation of the ancient monuments and archaeological sites in 1958. The object behind such restriction can clearly be seen that it is to protect the very structure of the ancient temples as these were built a long years ago. And your lordship, this temple, Jiravatma temple, was built in 623 and the excavation and the construction work which was carried out near the temple, it will certainly and undoubtedly affect the very structure of the temple. In section 28 of the said act, it has also been provided that the central government may permit the construction work if they satisfied that such other work or project, in its opinion, shall not have any substantial adverse impact on the preservation, safety, security of or access to the monument or its images around it. The lordship has the council already committed that since the temple is built in 623 and such heavy construction will certainly affect the structure of the temple, then how can permission can be given for the said construction? In the name of beautification, the heritage and cultural significance is being heightened because at the same time, there is a need to repair the temple itself, which is in dilapidated condition. The construction may affect the temple and its balance may be affected by breaking up if near the temple. If construction work would not be stopped, the identity of Odisha certainly collapse. Coming to the second principle, that is balance of convenience, it means it will cause greater inconvenience to the practitioners. If the status quo is not maintained, then the inconvenience to the opposite party would be put to if the status quo is maintained. It is considered that in the instant case, the balance of convenience is in the favor of the practitioner. If construction work is allowed to continue, the very purpose for which the CIIT has been filed, challenging the legality of the Coming to the third principle, that is irreparable injury. If the status quo order is vacated, it will certainly cause irreparable injury to the plaintiff. In the instant case, the opposite party is allowed to continue with the construction work. Then, ultimately, with the fear will be exposed out, the property will be gained first. Here, the main purpose of the PI stand collapse even prior to the judgment that will be given by this honorable court. Therefore, it is submitted that status quo order shall be maintained till the disposal of the KIIT application. Coming to the fourth principle, that is standard with the parties, since it is clear in the family case that is already highly noticed as part of the status quo order and the still construction is going. Here, the opposite party seems suspicious and malicious because even though status quo order was enforced, how can they continue the construction work? And they do not even want to wait till the disposal of the same PIL. And the honorable court shall take this fact into its consideration. And it also amounts to contempt of court Act 1971, which is defined section 2, clause B, that is disobedience to any judgment, order 33 of this committee. The petitioner 2 and petitioner 1 sorry, sir. Petitioner 1 is assist the foundation NGO and we maintain the status quo order, not practice.
Yes. What is the terroristic slide? What is the one?
Was part of 1956.
I think this is the figures. Then it's a first figures. It's one condition. This is for ones.
In the proposition, it has not been mentioned that which kind of status it is only been mentioned the status quo order of PIPA.
When we all what is that it would be the so that's not the last then is that one begin it's one and it is less and the and then we also need there's how
This issue, that the opposite party has found to on the committee the CPC since status quo is this petition has been filed after this clause. I take a part because the 6 June 27 rules related partly to the CPC, then go to the jurisdiction of the CPC. It is complete jurisdiction, and the opposing party has invoked the jurisdiction of the procedure. Petition, petition, status quo, certified, chapter 6, 27, 8, the act is read for the CPC since the same has been passed. When PI was the
they have made up the case that this vacation is a good business given. Party I will get up
six class 3 mentioned that within the state emotions.
these factors like the of parliament is you can take some of that opinions rather than go with the state and then might move. There is a lot of the additional and the issue should be positive. It is most somewhere that was in the in the state of current and state of management process goes 50 markets and others. In this case, and it objectives that what objective to be fulfilled only the related for. The two objectives were to see the ends of justice and prevent the action from the use of court that is already report. In this instant case, it is very evident from the facts and circumstances that of the state has frivolous false and fake charges or addiction because they came from a singular and registered their office and interesting and scale and so and came out the fact that the law was careful, identified and illegal acts of the constitution that are going on in the vicinity or in the name of In this particular case, offenses that are charged section 146, that is 148, 149, and section 162, 194, and 363 and 526. The very nature of the crime can be seen that this has been framed just to take a reference from that because they try to highlight it. So then the inevitable act of the law came out into the public. They didn't they were able to comply with this. That's why they framed charges, false charges, illegal charges, so that they can justify their what that are going on. And it has been already proved by my counsel that the construction activity that was going on was illegal. And in this particular case, they had the status quo order was enforced by the High Court. Still the construction was going on by the taking the police protection, taking the police protection. But in this case, the police should have obeyed the law that given by the High Court was by the law. But they defied the law, they defied the online with the order of the network. Still, they try to save the government by protecting the construction activity that is going on. Yes, boss.
To police statement getting ordered on the and was it destruction of something?
Individual answer. In this certain case, I am saying that in the proposition it has been said that then dates back to 623 AD, which means nearly for 2500 years back this temple was built and till now standing. So it's also have been mentioned in the fact that temple sanctum sanctorum was in a dilapidated condition.
Problems take a life. When we admit the fact that they have violence to this, then you find that yes. So now we understand actually the rich balance plan we ask me this one thing something are these only the principle and
Charges are completely false and frivolous. And the protest in the fact, in the fact, but I'm
what does it have when you want to then whether the fact of the base of base of if it is nature of the one, there's the problem. Is and it is wrong. There is so you must ask the time there is how can define is the way of the case. I think it's very sad that because given you extremely difficult for both that. So then you have to clear that what is needed and gain. And then after that, freedom of the and that one very and be very much
with the one protest began that for 5 years it takes to continue. Earlier, the first foundation went to the judicial body because they find the began from the strong construction doing not illegal. They protested at the very beginning. They protested with the status quo. Still, they are getting with the police protection. This to stop the immediate injury that is amount the temple by this excavation activity. Stop with out of range, people were to protest. There was no common intention because there was no of life. they gather on the protest platform. There is no such also plan that they want vandalize or break or anything within them. With this protest here, the government has that is the how this government they have asked they will be criticized. So different they will fight that. The petitioner is submitting this. And regarding the restriction is that fulfilled or not. The 146, that is a private charge. And already said that there was no meeting of rights, there was no common intention, there was no unlawful activity, that was the prosecution of unlawful activity of crime offense. So 146 is not met up. Since 146 is not met up, they have given charge of 148. Then I don't think if that is not met up, then 140 is also not made up. And regarding 149, then let's see that every member of all the guilty of offense right prosecution is common object. And I have already said that there are no common object. They went there just to see wow this construction activity is going on. There was no common object. People concerned about them. Not there is a collective intention of them who are having a particular thing. They went there to serve the cultural identity of the state. They went there to say the culture and the very spiritual nature of the state, which can actually collect state that they are constructing toilets. As toilets are discharging place and the temple is charging place. Then how can when 60 million people have sentiments, religious sentiments attached to a temple, then how can this construction activity go on? Even if it is hiding the sentiment, they will not find it or figure out a way. But the religious sentiment will not happen out, and the topics for them also have been solved. But out of maybe the government is very reluctant to you can say rebel. They don't want they don't want to suppress our that section 162. That is saying a certain of obstructing public service, suppressing or I think this section. If there are no common object, and there is no unlawful activity that is done in public of offense, again, that is not better. That's 150 also not better. And this is a very interesting thing that the devotees of God, section 94 IPC. Section 294 IPC says, in the case of Ranjit D, versus state of Maharashtra, and this Madan Gopal versus K. Lalita, which I have mentioned in page 16 of petitioner's memo, who said that obscenity ingredients can only fit in a word, or if there is a gesture, is done which tends to sexually influence thoughts, or there is something with substantially tendency, which has substantial tendency, or we find more evidence that there has been any kind of lustful desires, or there was any expression or gesture that has performed by the devotee, which will amount to lascivious or sexual thoughts could be arise from that. Since there is absence of this thing, we cannot attract 294 in this case. Since there was no material evidence, the accuser done any obscene act in the public place, nor they have sung, recited, or uttered any obscene song, ballad, or word. Moreover, the person who are protesting are devotees of Lord Nilamada, who are trying to save the cultural heritage and spirituality of the temple. The most to an extent, if they can do something, is they can sing the bhajan or kirtans of Lord Nilamada, nor any explicit or sexually explicit content they are going to utter or sing. Then if we come to section 353, it is assault of criminal force to deter public servant from discharge of his duty. A public servant cannot plead under section 353 if under an unlawful instruction from a superior, although he is unaware of the illegality. As it has been already mentioned by my counsel, that the construction activity was going on against the order of the status quo order, which makes the act prima facie illegal.
and contentious. Still, the act was going on. So here, since the act was illegal, the construction activity was illegal. So the public servant there cannot plead 353 in this instant case. And if we come to section 427, the three essential ingredients, that is misdeeds, has been defined under the 427. The three essential ingredients has to be filled. And if any one of the ingredients is not fulfilled, then 427 cannot be attracted. The first ingredient, that is of intentional or knowledge. As I have already said, that there was no common intention, there was no intention of vandalizing or destroying any public property. They went to save the cultural heritage and the identity of Odisha, not to destroy or vandalize anything. So hence 427 is also not made out because there was absence of intention and knowledge. Then if you come to 506, that is criminal intimidation. In this particular case, there is no material evidence which shows that they have a criminal intimidation or they have any intention to create ruckus or intention to create any criminal activity in that particular vicinity of the temple. So from the above explained in argument advance, can be clearly seen the charges that have been framed in the FIR lacks evidence in support of the same and do not disclose any commission of offense. The state has blatantly misused the government machineries to hide the erroneous activities by framing false and frivolous charges against the devotees, that is the protesters. To secure the ends of justice and to save the accused from the abuse of process of court, the FIR should be quashed to serve justice. If it may please your lordship, the council would like to proceed with the prayer. Therefore, in the light of issues raised, argument advanced, and authority cited, the counsel for the petitioner most humbly prays the honorable court would please to adjust, hold, and declare to maintain the status quo order and to quash the FIR that has been registered on the petitioner and pass any order that this honorable court deem may fit in the interest of equity, justice, and good conscience. Much obliged.
And we are getting our doubt that why this different proceeding should be passed at a very good level. Why it could be required or we are allowed to go on, so that whether there is a conflict or someone has the intent to commit a crime, that prove that part. Why is this the time to work?
Indeed, your lordship.
The reference. We never get the reference to that.
Yes.
Never get the reference of that.
Okay, your lordship. Yes, your lordship. I'll take that note, sir. The citations have been given in the footnotes. I was unable to mention that. I plead ignorance for that. Yes, your lordship. Since it can be prima facie seen that the protests were to... no, your lordship, that was not provided by the facts. In fact, yes, your lordship. So since there is a provision under 482 of CRPC that the FIR can be quashed to save the accused from the process of court if false and frivolous charges have been framed. And here in this instant case, the petitioner believes that false and frivolous case have been filed against the petitioner. That's why we have come under the jurisdiction and I plead your ignorance. Yes, your lordship. Yes, your lordship.
Then you get to know under what circumstances and the client can be caused. Either under or there are 6 guidelines from the documents. And if the government is that, then people will explain as to under which clause from the people of the year those cases was. If you are placed under the clauses, without the honorable suggestion of activity, then is the next item to maintain and the apply to do.
Your Lordship, in this state of Haryana versus Bhajanlal, we have given the citation page number 18. Yes, Your Lord. Your Lordship, we haven't mentioned the clause.
6 or 7
Ignorance.
by the honorable effect.
Yes, Your Lord.
Your entire argument is on the abuse of process of court. So look at the judgment. Abuse of process is the last resort. There are 6 before that.
I was the one there, but see, he has a difficulty. He has a difficulty
Yes,
because
FI
the FI is not there.
Yes.
So what you could have argued is, I think subject friends here, you have argued, FI does not say particular what act has been done. And it is a generic FI saying that the entire FI is not supposed to be transparent. It says that there is a renewal of the motion. Fact remains that the FI, if it means these people. So then you can take center of this. But extremely okay. Rarest of the rare cases, 484 or 26 to be exception. You are so you have told that this FIR is vague, nor is there also investigation and there is no 161 as to who did this one. And there is a huge crowd, even if there was the worst case, conviction. So that should be. I mean, I quite agree that he has had a problem.
Yes.
He has had a problem. Good. You did it well. But don't hurry. But I know this is supposed to be negative to the, they will learn from my suggesting to you. Don't be in a hurry. Because we are not catching the train in the nearest station. You argued very well, your clarity is there. But you should have first said that the FIR is not a gospel, but it was very substantial under 154. What is the offense and who has committed it? Here, the FIR is not there with us. It's very difficult to. I mean, it is difficult by any standards to argue. You argue very well. We are not finding fault with you. We are just saying that the difficulty is Bhajanlal says there's 5 to 6. And that law has been there for a long time, but it still continues to be good law. You should have cited, according to my learned friend, you should have cited, said Bhajanlal first. And see, now all of you must realize that when you are arguing a case, you should first see the section. Because the section is the set, and that is the will of the legislation. Okay. So don't jump to Bhajanlal's or any judgment before you understand as to what does the section say. So you argued well, no opinion, and you have tried to make out a case which according to us probably was not there at all. I mean, because the FIR is not there, what will you ask for watching? Okay. There are 3 from each side, huh? Come.
The council for the respondent seeks permission to proceed with that.
You don't have to seek permission, you have the right.
Respondent would like to submit the complaint matter. The council for the respondents now seeks permission to begin.
Please go ahead.
Much obliged, Your Lordship. Reading from the case, the honorable bench. The council solicits permission to call the bench, let the bench collectively as the honorable bench or individually as Your Lordship or sir.
Don't address us with anything. You begin your matter.
Your Lordship, I and my co-counsel represent the respondents in the incident matter. PIL filed under Article 226 of the Constitution of India, Aswati Foundation Trust versus State of Odisha and Tata Project Limited, clubbed with petition to quash FIR filed under Section 73, Drama Trust versus the State of Odisha. Your Lordships, we have divided our argument into four issues. The first issue will deal with the maintainability of the public interest litigation as well as the petition to quash the FIR. The second will deal with legality or illegality of the construction activity undertaken. The third would deal whether the FIR should be quashed or not. And the fourth deals if the vacation application for the status quo order pass should be allowed or dismissed. Your Lordships, I will be dealing with issues 1 and 2, while my co-counsel will be dealing with issues 3 and 4. If your Lordships are well versed with the facts of the case, the counsel for respondent seeks permission to proceed with the first issue.
This way.
If we are not well versed,
Your Lordship, may I say,
if we are not well versed, then
Your Lordship,
no, you said if you are well versed, then I'll proceed. We'll say we are not well versed. Then you have to again go right to square one. So your time will be over. Go ahead.
Your Lordship, the first issue is whether the matter is maintainable before the honorable court or not. It is humbly submitted by the counsel for the respondents. The first contention for the same is that the PIL filed by Aswati Foundation Trust is not needed. It was held in Ramdas Foundation versus Union of India, AIR 1993, Supreme Court 852, that a writ petitioner who comes to the court for relief in public interest must come not only with clean hands like any other writ petitioner, but also with clean heart, clean mind, and admit that the PIL is abusing the process of law. Justice Krishna Iyer once remarked that the doors of the court should not be ajar for such vexatious litigants who abuse the process of law. We say that there is abuse of process of law because the PIL file is devoid of any merit. We contend so, your Lordships, because for the jurisdiction of Article 226 of the Constitution, the jurisdiction of PIL is under Article 226 of the Constitution, there could be any legal wrong or legal injury in the first place. Wrong or legal injury for Article 226 to be applicable could be in violation of any fundamental right or any constitutional right or any other legal right for that matter. The activities that the state had undertaken was we, on the other hand, are respecting the fundamental rights of visitors under Article 21 of the Constitution, under which right examination has been held as one of the inalienable rights, as well as Article 25, freedom of religion is being respected by the state of Odisha. Along with this, I would like to draw the attention of the portion Article 19+1 It talks about the freedom of any citizen to move freely throughout the territory of India. It is for the convenience of these visitors and tourists that the construction activities were undertaken by the government of Odisha. My next contention for the state maintainability of public investigation is that the PIL is impeding the convenience of larger public interest that here is development. I would now like to draw the attention of section 30 of Sri Jagannath Temple Act 1955. Your Lordship, 30 of Sri Jagannath, it is in the compendium, Your Lordship. Section 30 of Sri Jagannath Temple Act 1955 talks about the power of state government. It reads this first subsection reads that subject to the provisions of this act, the general superintendence of the temple and its endowment shall vest which may pass any order which may be necessary for the proper maintenance or administration of the temple or its endowments or in the interest of general worshipping in the temple, Your Lordship. We say that the construction activity was undertaken for the objectives of convenience of innumerable devotees. It is written in the Moot proposition, I think in the third page of the brochure, that around 60,000 devotees used to visit Veena Mata temple every day, every single day. Our festival, the number rose to 50 million. It is for convenience of those innumerable devotees that the construction activity is undertaken. Now, the other objective was that proper discipline would be maintained. We have not just proposed to build toilets, we have also talked about shelter areas being constructed. Proper use will be, which would direct the crowds to the main temple. This would lead to convenience, better darshan of the devotees as well. This is mentioned in para 4 of the proposition, Your Lordship, that it was for proper discipline. And the third objective was the proper health and well-being of the devotees and other visitors, as per para 5, is I had mentioned that it is in respect of Article 21, the fundamental rights. It is held that right to sanitation comes under it. I will cite a judgment on the same regard in my later arguments. Now, I would like to move to the maintainability of petition 5 for quashing the empire. It is humbly submitted by the council.
Pausing here. In fact, there are two issues coming to my mind. One, you said ki in view of Article 21. So even during the time when the status quo is in force, the construction work could go ahead. Another thing you said, by quoting section 30 of the General Act, and you in the act it is very much there. The section it is very much there, subject to the provisions of this act. Right. So the doubt that has cropped up is, could Jagannath Temple Act be made applicable in this particular case? One, because the applicability of that particular statute that is confined to only Jagannath Temple, not extending to any other temple inside the state of Odisha. Then second question is, when there is a status quo order, how could you go ahead with the construction work without seeking for a modification of the order before the Honorable Court? When you did not seek for a modification before the Honorable Court, then would your action of constructing a whatever toilet or washroom, whatever, be construed to be a legal act?
Answer the question regarding the applicability of Sri Jagannath Temple Act. If we see the preamble of Sri Jagannath Temple Act, it talks about Lord Jagannath Temple, and the description which is provided for Sri Jagannath Temple is of national importance, and a lot of devotees come there, and is in the state of Odisha. About the car festival is also written. Proposition in the very first paragraph, the entire corollary can be drawn from Veena Mata Temple as well as Sri Jagannath Temple. However, Your Lordship, we admit, we the council for the respondents admit, it only has a persuasive effect and not an authoritative value. We were appealing to the wisdom of Your Lordship as the court is entering into effect, the guardian of the people. However, Your Lordship, we would to ancient monuments and archaeological sites.
That means you agree that Jagannath Temple Act is not applicable. Because you are now switching over, hopping to another statute.
Your Lordship, I was referring to this because in 2021, Kumar judgment was passed, and the construction related issue, Lord Jagannath, it was in relation of Lord Jagannath Temple related issue is the same as Veena Mata Temple and construction related issue. So we were trying to show how it was the Honorable High Court of Odisha which has passed the judgment in our favor, and and therefore we were showing that how it can have a persuasive effect.
In our favor, matlab?
That the construction activity for toilets were allowed in our opinion, Kumar asked us. Your Lordship, may I proceed with the second? Your Lordship, may I proceed with the second question of why we consider?
Let me just clarify. My learned friend was asking for a very important reason for it to you. You responded very well. See, the idea is that fundamentally where there is no statute covering you, except the Ancient Monuments Act and the Archaeological Act of India. What happens is that you have to draw a parlance. So you drew a parlance from this act. But what my learned friend is driving you at is that first you should have said that this is what has been done by the Orissa High Court on interpretation of the Jagadhar Temple Act, and it is essentially Article 21, where you are creating a more homogeneous atmosphere for the believers who are coming in, and therefore it is in larger public interest to do that. All three of us agree that you what we asked, you replied. We must say that. So you continued that. You really did respond very well.
Your Lordship, I will that in mind probably next time. So why the construction activity was actually the issue is the third issue is dealing with that matter. Council would be dealing, but I will just briefly answer your question, Your Lordship. There was this judgment of SS Dalia versus Union of India. A few moments back, the Lordships were asking what is the qualification of the status quo order. It can either be for stopping or for continuing. It was held in that case that if the status quo order is passed when the construction act, when any activity is being undertaken is for public interest, then the order would lead to continuance of the work. Furthermore, my co-counsel would be dealing with that matter. I would like to proceed with non-maintainability of petition to quash the FIR election. The first argument of the respondents for the same is that the High Court cannot quash the FIR as it is made out of a cognizable offence. It was held in Balkar Singh versus Jagdish, 2005, All India Reporters, Supreme Court Meeting 1034, that when a FIR is made out of a cognizable offence, the High Court does not have the power to quash the FIR election. If we see the charges levied in the FIR, it includes section 146, 149, 152, 152, and 353, which are cognizable in nature, Your Lordship.
You pause here for a moment. You have done very well. I'm only saying, let us all be clear in that. 154(1) gives the power of inquiry into a cognizable offence to the police. Okay. That the High Court doesn't have power. What has happened from that previous judgment that is there, earlier judgment of that Muslim name in 45 or 45, that has been referred to in Madhusudan and all these judgments. See, the idea is fundamentally we must understand that when you are quashing an FIR, what is in the domain of the investigator, the High Court under two petitions should or not ordinarily. So that is what you are driving at, but you should say ordinarily interfere, because High Court judges get very upset if you tell them they don't have the power. So never say that. Thank goodness we are not High Court judges.
My very next contention was related.
Now, one more aspect. I just add. You said the High Court cannot quash an FIR when a cognizable offence is made out, right? I think this proposition is absolutely wrong. The reason being, the police will register an FIR if at all a complaint makes out a cognizable offence. If the complaint does not make out a cognizable offence, then FIR cannot be registered. It has to be made a station diary entry. Then, if it is a non-cognizable case, then the police has to approach the learned magistrate On getting a nod from the landed magistrate, the police can take up the investigation. So this proposition that you in fact formulated is quite wrong.
Your Lordship, I would like to take the attention of the court that the FIR was not sought by any individual, that no individual had approached under section 154 of the Code of Criminal Procedure to the police to file the FIR. The administration had taken suo motu cognizance, Your Lordship. And if we see section, if I'm not wrong, section 124 of the Code of Criminal Procedure, where it says that the executive magistrate has the power first to give a warning, and if the crowd does not disperse, which is violent, protesting,
That is on a different aspect altogether.
then the administration may file an FIR, Your Lordship. Here, because the administration filing, therefore, both the cognizable and non-cognizable matters for Your Lordship.
Not correct.
Your Lordship, then I would also like to mention that one of the points of state of Haryana versus Pakistan was about the cognizable offense.
Yes, yes.
Does this satisfy Your Lordship?
Honestly speaking, I didn't know as much as you know. Appreciate that. Your clarity is enormous. All of you are much better than us. At least me.
It is very humble statement of Your Lordship.
I agree.
Very humble statement of Your Lordship. Your Lordship, my very next contention was that the FIR cannot be quashed when investigation is still pending. We must appreciate the fact that the Moot proposition only mentions that these sections were charged as per the FIR. However, investigation is started. However, investigation is not completed here. Once the investigation is completed, only then the High Court has power, police report and all. Only then the High Court has power. It is held in State of Punjab versus Kumar 2004, Supreme Court case 437, that High Court should not act as an investigating agency, and court cannot delve into the actual arena when quashing the FIR. There should be a prima facie case. What they were doing was delving into the factual arena.
But you don't have an FIR.
Your Lordship, we have an FIR.
Where is the FIR?
Your Lordship, it is not provided in the proposition.
So that is what the problem is.
Your Lordship, but Your Lordship is telling that it is not said that who has done which activity.
No.
I would like to take the attention of Your Lordship to move proposition paragraph 6. I would like to read it out, Your Lordship. The main purpose which the FIR would have facilitated is giving the move proposition, Your Lordship. Amongst them, one person, namely Ramasabu, out of rage, not Keetan, Your Lordship, out of rage, broke metal barricades of police and
Yes.
started burning.
I stand corrected. Yes, it's there.
Okay, much obliged, Your Lordship. I would like to proceed with my next argument, that is the FIR was neither maliciously instituted nor manifestly unjust. It was so remarked in state of Karnataka versus N. Muniswamy and others, AIR 1977, SC 1489, that so long as there is enough people on record to connect the crime and the accused, the High Court does not have a jurisdiction to put a premature end on the belief that the prosecution is not likely to succeed. The facts evidently prove the one that I was going to quote. The facts evidently prove that Ramasabu out of rage started burning tires, and then the general public, including the members of Initio, destroyed public property. So we have even prima facie a case against the accused, which is the general public. So the grounds of maintainability are not fulfilled. The grounds of maintainability of questioning the FIR is not fulfilled. Therefore, it is humbly submitted that the same petition should not be allowed. Now the council seeks permission to proceed with the second issue, Your Lordships.
This one.
Much obliged, Your Lordship. The second issue is whether the construction activity undertaken by the respondent is legal or not. It is humbly submitted by the respondent for the respondent that the construction activity was lawfully undertaken as first convention, the construction activity complied with the provisions of ancient monuments and archaeological sites and remains Act 1958. I would like to take the attention of the honorable bench to Section 2, Clause 3C of the Answer Act and read out the same. Just a minute. Like I say, entire provision or just the relevant provision?
Relevant.
It is from the second line, Your Lordship. Construction, it is the definition of construction. It does not include any reconstruction, repair, and renovation of an existing structure or building, or construction, maintenance, and cleansing of drains and drainage works, or of public latrines, urinals, and similar conveniences, or the construction and maintenance of works meant for providing supply of water to the public, or construction or maintenance, extension, management, or supply and distribution of electricity to the public, or provisions for the similar facilities for public. What we need to submit from citing this definition clause is that we would come into the question of section 28, 20B, 23 of the Answer Act only if the definition of construction includes these activities, Your Lordship. We see that expressly these kind of activities is here is that the legislative, the intent of the legislature while forming this statute was clear that these essential services which cater the needs of public at large should be consciously kept out of the definition clause of the construction, Your Lordship. Also, Your Lordship, I would like to take the attention of the honorable bench to paragraph 3 of the Moot proposition, where it is mentioned that the legalities were completed, Your Lordship. There is no question of taking permission and seeing that if the construction complied with the Answer Act or not. If the competent authority, as per Section 2, Clause 3B, has given a green signal and the legalities are completed in the first place, Your Lordship. This was all about the Ancient Monuments Act, Your Lordship. The next contention is that the construction of toilets was essential for public hygiene. First, the activity was initiated in the interest of public health. If we see Article 25 of the Constitution, Your Lordship, it talks about freedom of conscience and free profession, practice, and propagation of religion. However, if we go on to read subsection 1 of Article 25 of the Constitution of India, it says subject to public order, morality, health, and to other provisions of this part, Your Lordship. What we need to show is that it qualifies the construction activity, the building of toilets qualifies the public health and public order for the shelter homes and public health for the construction of toilet works. It qualifies these restrictions on the exercise of freedom of religion, Your Lordship. Also, it was held in Govindpalji was the state of Rajasthan, AIR 1963, SC 1638, that freedom of religion cannot be absolute. Again, in Ratilal versus State of Bombay, Sekuddin versus State of Bombay, it was remarked that whether the ritual, observance, ceremony, or other activity which has been interfered with is an integral part of that religion or not should be prohibited. And this is because the protection must be confined to such religious practices which are essential and integral part. And if not, then it should not be, Your Lordship. What we need to say is that Article 25 and Article 26 of the Part 3 of the Constitution only protects essential religious practices which qualify that. The only thing mentioned in the Moot proposition is that religious sentiment of a group is being religious sentiment of the group is being affected. First of all, sentiment is not equal, does not imply religious practice. Second of all, even if it is a religious practice, it does not qualify essential religious practice. I would also like to state that the activity was in consonance with Part 3 of the Constitution. In National Highway Projects was the state of Bihar, 2022, when very recent judgment. SBC online, Patna High Court had remarked in page number 1048 extension. Patna High Court had held that right to sanitation is a fundamental right under Article 21. Sanitation is not only about individuals' right to access the toilet or bathroom. Inadequate sanitation leads to contamination of environment. Now, the property resides in the main temple, Your Lordship. Contamination of environment, public spaces, water bodies through feces and waste. The last argument for the same is that it is the duty of the state to ensure public health. As per Article 38 and Article 47 of the Constitution of India, policy. It is an obligation of state, for that matter, to improve standard of living and public health of the citizens. The work that we had undertaken was in line of this election. It was held in Binani Freddy versus Union of India 2019 18 SPC 1 that when there is a vast congregation of people, it becomes the government's duty to ensure welfare, law and order, hygiene, and provide proper amenities and sanitation. One is in violation of what the Constitution as well as the law provides us.
That judgment is with regard to COVID restriction.
Your Lordship, but indeed, Your Lordship, but the ratio that is decided is even applicable in this case, Your Lordship, because it deals with space.
Yeah, we can extend for 5 minutes because we have disturbed her enough. If you want 5 more minutes, we can give you if you want.
Much obliged, Your Lordship. And the last case that I refer now is Ratlam Municipal Corporation versus Bharti 1981, Supreme Court Reporter 197. The state is under an obligation to make sure that the standard of living of people is high. For all that we have done, we only propose that the concern of general public, visitors and tourists were our objective. We have undertaken this construction activity not against the practice of their religion, but to make their religious visits more convenient. It is humbly submitted that the construction activity was carried out within the law of land. Further, my co-counsel will take up the case. It was indeed a pleasure to argue before the
You represented whom? Tata Projects or the government?
The state of Odisha as well as Tata.
So as Tata Projects is concerned, you going to get money out of it. It's a contract.
Lordship, because Tata Project has become a party by filing the vacation application, so we have
What
to
happened?
represent them as well.
Thank you.
The council seeks permission.
Please go ahead. Don't have permission. You have to have permission because we have, once you're qualified for the final, you have everything to. You can shout and yell at us also.
Are revealing issues 3 and 4. The third issue is whether or not the FIR against the protesters should be quashed. The council seeks permission to proceed with the same. It is humbly submitted before the Honorable that the petition filed for quashing the FIR is frivolous and vexatious in nature. In order to prove this, at first that is bring the attention of the court to section 141 of the Indian Penal Code 1860, which defines an unlawful assembly. The first essential ingredient of an unlawful assembly is the presence of 5 or more members. Now, if we look into paraphrase of the proposition, it is mentioned that the people who are part of this protest were the members of the NGO as well as the general public. This implies that the number of people present in the protest were more than 5. And satisfying the first ingredient required for unlawful assembly. Now, moving on to the third ingredient of section 141, it mentions that an unlawful assembly, an assembly which consists of 5 or more persons, and it commits any mischief or criminal trespass with the intent to cause or knowing that he is likely to cause wrongful loss or damage to the public or to any person for the destruction of any property or any such change in any property or any situation thereof as destroys or diminishes its value or utility or affects it injuriously, commits mischief. Now, if we go by the facts of the case, we can see the drama Sabhu, along with the general public, have started destroying government property, which suggests that they had intended destruction of the property, which destroyed as well as diminished its value as well as utility. Now, if we look into the explanation of section 141, it has been mentioned that an assembly which was not unlawful when it assembled may subsequently become an unlawful assembly. Now, even if we assume that the protesters had come and they had started protesting peacefully, construction sites, including the burning of tires, breaking of barricades, as well as breaking down signboards of the government, all of this suggest that the assembly had turned unlawful.
Good.
Now, I'd like to cite the judgment of Kumar versus State of Haryana, 1961, Criminal Law Journal, 1970, which suggests that common intention can develop at the spot as well. So again, even if we assume that there did not exist any premeditated plan with regard to the development of an unlawful assembly, the act of mass, as well as the general public, imply that there was common intention, and the acts of them were in furtherance of the common intention. In addition to this, section 149 is also adapted, which talks about common object. It reads that if any offense is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object, every person who at the time of committing of that offense, the member of the same assembly, is guilty of that offense. So even again, if we assume that the general public, only a few members of the general public were involved in the protest, the violent protest, and others were not, then their presence in the unlawful assembly made them liable under the. Now, if we look into section 427, which the protesters have been charged with, it is an aggravated form of the offense of mischief, which talks about damage so caused, and it is of the amount of 50 rupees or upward. Now, if we look into the acts of sedition, which include burning of tires, breaking of barricades, as well as bringing down of signboards of the government, all of this cumulatively suggests that there can be a loss of 50 rupees or more. Hence, making this section also applicable. Now, if we look into section 140, it deals with the offense of rioting. Now, an essential ingredient of rioting is unlawful disorder. I have already established that there was unlawful disorder. So, there is a reasonable apprehension that the protesters were also involved in the offense of rioting. On to section 152, 186, and 353, which deal with obstructing or acting as an obstacle to the act of the public servant. For this, I'd like to bring the attention of the court to section 21 of the Indian Penal Code, which defines who a public servant is. Now, the 12th ingredient of section 121, it states that every person in the service or pay of the government or remunerated by fee or commission for the performance of any public duty by the government is a public servant. Now, if we take into consideration the fact that Tata Project Limited, which was a private organization, was had been provided with the responsibility of all this construction, we can say that it was in service of the government. Hence, it can be brought under the ambit of section 21 as a public servant. So, all the charges which have been levied on the protesters with regard to section 152, which deals with voluntary, which deals with any assault towards a public servant, 186, which deals with voluntary obstruction of the public servant in discharge of any function, on 353, that is criminal force or assault towards any public servant in discharge of any function, these will also be made applicable. Furthermore, if we look into the section of 560, which deals with criminal intimidation. Now, for this, we have to see the definition of criminal intimidation, which which had been provided in section 500 and 503. Here it has been provided that whoever threatens another with any injury to his personal reputation or property or to the personal reputation of anyone in whom that person is interested with the intent to cause alarm. For this, I'd like to refer to a judgment that is Vinay Chhabra and others versus Ms. Vera. In this case, it has been stated. I'm sorry. Actually, I was referring to Amulya Kumar Behera versus Madhusudan Behera, alias Naveen. 1995 Criminal Law Journal, 3550. In this case, the ambit of alarm was decided. Here it was stated that alarm can be synonymous to terror or distress. Here, the fact that there was a disruption in the traffic which had been caused, it did lead to great levels of distress amongst the general public who were affected by such an act of protesters, which make them liable under Section 506 of the Indian Penal Code. Furthermore, if I look into the fundamental rights aspect, Article 19 Clause 1B of the Indian Constitution provides the citizens with the right to dissent. However, like every other right, Article 19 Clause 1B also subject to certain reasonable restrictions. These have been provided under Article 19 Clause 2, which has stated that if the protest if the threat acts as a threat to public peace, public order, and security of the state, it shall not be provided for the protection under 19 Clause 1B. Now, public order has been greatly affected. Even the public peace has been greatly affected because of this protest that had commenced at the construction site. Mainly, if we focus on the destruction of the traffic, there were so many people who were affected by this protest. There might have been ambulances waiting to go to the hospital. There might have been many other people wanting to go to their place of work or any other urgent need. Hence, public order, public peace was greatly affected. Hence, this particular protest was not protected under Article 19 Clause 1. Now, moving on to the grounds of quashing FIR, which was provided in the case of State of Haryana versus Budget Plan, there were 7 grounds which were provided. Firstly, that the non-interference by the High Court will lead to miscarriage of justice and delay in further investigation. Furthermore, that the allegations in the FIR constitute only a non-cognizable offense, contrary to the justification undertaken by the police. 1 of the Code of Criminal Procedure for proceeding without the order of a magistrate, that the proceeding is maliciously instituted for wreaking vengeance on the accused and the personal grudge leading to manifest unjust FIR even without delving into the spite involved, that the Code of Criminal Procedure or the concerned act expressly bars the provisions of the code from being applied or where there is a specific provision in the code providing alternate efficacious remand redressal mechanism. Fifth is that the investigation proceedings have been without any cognizance or delays for being disproportionate to the offense. Last, that the allegations made in the FIR are inherently improbable and absurd, and no prudent man could conclude that there is sufficient ground of proceeding against the accused. All of these grounds have been disproved by myself as well as my co-counsel, hence making this, acting as an obstacle towards quashing of this particular FIR. Furthermore, I'd like to state that it is a settled principle that an FIR cannot be quashed by the High Court by traversing into the factual arena when the investigation is still pending. Like I have already mentioned, that the investigation was still pending, there was no police report filed, there was no trial proceeding which had been undertaken. Hence, this the quashing of FIR cannot take place. Furthermore, there has been evident palpable commission of cognizable offences that I have already explained as to why there were certain cognizable offences charged against the protesters. So, without going into the merits of this case, an FIR cannot be quashed when the commission of offence was prima facie not disclosed. Hence, it is humbly submitted that the petition for quashing the FIR shall be dismissed by the Honorable Head. The Council seeks permission to proceed with the fourth issue. whether or not the status quo order against the construction work by the respondent be vacated. It is humbly submitted that the status quo order against the respondent must be vacated because first was made in interest of the public. Like my co-counsel already mentioned, that public interest forms an essential ground for the continuance of the construction activities. The Holy Temple of Neelamata is not just of national importance, but is also of international repute, which has been mentioned in the first para of the proposition, which suggests that it has 50 million followers all over the world. The government has spent approximately 3,200 crores worth revenue in this particular heritage project, and this is solely for the purpose of making the visit of the tourists easier to the temple, enhancing their convenience, ensuring proper discipline at the time of entry into the temple, as well as ensuring their health and well-being, as has already been mentioned by my co-counsel. That is, their right to sanitation and be protected under Article 21. Furthermore, in the case of Kumar a case with similar factual metrics as the case in hand, it stated that public interest here is nothing but construction of basic amenities like toilets and cloakrooms, which are of paramount importance when we speak of convenience of the public. Next, I'd like to mention that the respondents have undertaken such beautification, which will not just help in benefiting the convenience of the public, but also will pool more revenue for the government, which can be utilized for the development of the temple as well as the area surrounding it. Lastly, it is pertinent to note that the government had spent 3,200 crore worth revenue, which was the money of the taxpayers, and it had already been invested, and the project had already started. And if this particular project was done away with, then this money of the taxpayers will be pushed off the cliff. As a result of this, government taking into consideration the interest of the public, mainly the taxpayers, has allowed the continuance of the status quo order. Hence, it is humbly submitted that the status quo order shall be vacated by the Honorable King.
Shall be vacated or shall not be vacated? Status quo order shall be vacated. Status quo order against you.
So now I'd like to proceed with the
So now the catch is, so you are saying if you are going ahead with the construction work, and you say the construction work that is being undertaken is legal, then why the need of vacating the status quo order? Now status quo order is in force, construction is going ahead, you are saying it is legal, then what is the need of vacating the status quo order?
The fact that the petitioners have actually misunderstood as to why the status quo order has been passed. They have assumed that it has been like the status quo order has been passed with the objective of stopping the construction activities, and hence they continuously acting as a hindrance towards the construction of these structures which are aimed at the convenience of the public. Now, continuous protest, if they continue after like time and again, then it will continue to act as an obstacle to the construction activity, hence delaying this particular construction, which will ultimately affect the convenience of the public only. Because if structures are created,
well, very well.
if structures are created, bricks have been created for the purpose of construction, then it will be inconvenient to the public only to move into the temple. So as the orders shall be vacated for the sole reason that keeping the interest of the public in mind, in order to accelerate the process of construction, we are aiming at completing the construction process so that the convenience of the public is ensured.
Good. But then there is another thing that you should have talked about, no? That this is essentially within the domain of the administration. It's a public, it is a policy decision made by them to develop that thing. A policy decision cannot be interfered with, except for very good reasons in the PIL.
And another aspect, clarification. Any individual not in the employment, government employment,
Cannot be.
Can he be a public servant under section 21? Like a private, any person appointed with a company, private limited company. If at all they are going ahead with the construction work, which is being developed by the government, could any individual of a private company be termed as a government servant, a public servant?
Your
And
Lordship, the 12th ingredient mentions every person.
no, you please come to section 21 IPC.
Yes, Your Lordship.
And you read section 21 and then wanted to link it with the Tata employee by saying since they are carrying forward the work entrusted to them by the government, so they are also public servant.
Yes, sir.
But is it the definition?
The 12th ingredient mentions that in the every person in the service or pay of the government or remunerated by fees or commission or for the performance of any public duty.
So in the pay of the government,
Yes.
in the pay of the government. Yes.
So we can assume that Tata Project Limited was getting some amount of payment with regard to the construction activities which have been undertaken.
That's a very innovative argument. Good. I mean, because see, law is that if a private organization is doing public duty, it is amenable to a PIL. Okay. That Nari Niketan, the line of judgments that are there, you see in that. So therefore, yes, you are driving that to an extent which is admirable. I mean, it is something which three of us couldn't have thought. I can assure you. And I must say, now you are complete?
Yes, sir. Just proceed with prayer.
Yeah, prayer.
So now I'd like to request my co-counsel and a respondent, I'm sorry, my researcher, to proceed, come to the desk and repeat the prayer.
Now, come. He was a researcher, he's outstanding then.
Yes.
He is like the director of the film. You are the actor, actress.
In the light of the issue raised, arguments advanced, and authorities cited, there is honorable court will please to declare and hold that the present PIL filed under section 226 of the Constitution of India is not maintainable. The construction is legal and the government may proceed with the same. The petition which has been filed for quashing the FIR is not excluded and pass any order or direction or relief that may deem fit in the best interest of justice, fairness, equity, and good conscience. And for this act of kindness, respect shall forever be.
Well done. Both the teams are outstanding. I must say.
And
who are
give
the-
a rejoinder? Do you want to give a rejoinder?
They have a right to a rejoinder. They have a right. Yes, please. I thought that in our time we were never given this opportunity. So. Delhi University, I think Before you proceed, I just want to find out how many teachers are here there who are teaching here now. How many of you are there? None of them. Okay. But anyway, I must say that I don't know if you're self-taught or otherwise. I'm really proud of the fact that I think two of us you have come to this college or not? Yes. Two of us have been from this college, and my learned friend, he went away near his home, so didn't come so far. But I can assure you, I mean, you all make us proud.
Sir,
Yes, please.
neither in the portal submission or in the memory, the respondent has materially made evident that the construction of the central pavilion and the place to stand in for the toilet were defined or under which provision this carried out, because it is completely in violation of the section 2D of the AMSAR Act that has been provided by the ASI. And second thing is they have approached the chapter 27 of High Court read with order 29 of hence their application for their application is rejected. It is not because and it is a written High Court that had been if it had been a then they would have invoked the rule of the PPC under order 39. But this is the petition. So in this particular order, the PPC that is order 39 of rule 4 cannot be invoked because in this petition under the stay order of the power. Then only under of the Indian Constitution, the stay order neither as that has been prescribed under the High Court. And other thing that I would like to remark is while the construction activity was going on, if the status quo order was passed, they made a mere assumption that the petitioner was confused by the status quo order that if the construction work should go on or not. Your Lordship, we are not confused. Status quo order means that the state should be as it is when the order was passed. And when the order was passed, the status quo order, then the construction activity should have been stopped from that particular moment. Then why the construction activity went? That amount of contractor code. So this one I will back to
just one. Your interpretation of status quo order, like say somebody is supplying flowers to the temple, and there is a dispute for giving, when somebody else says that he doesn't have the right, I have the right. Court orders status quo. Court orders status quo between the parties. Will it mean both the parties will cease to give flowers to the Lord and the pujas will stop?
The Lordship, putting the flowers, offering the flowers to the Lord is not amounting to any physical activity, nor it is amounting to destruction of the temple vicinity or the temple complex. But here the construction activity that is in question is affecting and destroying the temple, and it also changing the very spiritual nature of the temple. That's why the flower part and very can be said parallelly in this case. And also they have
Smart answer.
They have also mentioned about the Jagannath Temple Act. It is nowhere mentioned in the proposition that the Niramana temples and Jagannath temples are parametric with each other. Then they are trying to mislead the court by putting the Jagannath Temple Act here. That's what I would like to submit in this report.
For the respondent seeks permission to proceed with this
Second rebuttal, do you want to do? Is permitted? Aja. But I thought what I understand of the law, you only have a right to answer on the point of law. If at all there is any clarification of point of law. Anyway, since you have a even playing field is there, go ahead.
The first one they had, I would first like to give the statistics they had levied against us and then show the group codes in their application. They are talking about cloakroom, mini cloakroom, shelter room and pavilion facility that we have not talked about it. We had done a joint reading of construction activity adoption, and where we even saw that maintenance, extension, management, administration were excluded from the definition of construction adoption. The second condition they said was that the status quo order, the jurisdiction of status quo order that we contend that is under section 151, regulated section order 39 June 1 of the Code of Civil Procedure. Let us assume that we do not file it under that, and we go by what they have said, the petition article 226. And article 226 plus 3, we have this order was passed. There is no need of filing the vacation petition. They are making a and the validity of that order is only of 2 weeks, Your Lordship. This is what we would like to show. The third thing they have again pointed out that we went on to assume that status quo order means that we should continue the activity. I made it very clear, and even my co-counsel had responded on the same, that in SS Dahlia was the Union of India, and we have other authorities to cite as well, that when a public interest work is undertaken, the qualification of status quo order means to continue with the existing state. It is not that after status quo order was passed, we started the construction activities. Even before the status quo order was passed, excavation and construction activity were being undertaken. That is, the existing state was, construction was going on. And here also I made it very clear that this is having a persuasive effect and not an authoritative character. Now the council for responding seeks permission to point out the flaws in the submission of petitioner's lordship. Much obliged, Your Lordship. If you see the issues they have dealt with, they only deal with vacation application of status quo as well as petition for quashing the FIR. The main root is the PIL file, Your Lordship. It does not even form a part of the issues that they have dealt with. The second thing, they have raised the question of balance of convenience, Your Lordship. We would like to say that there is only one convenience that even petitioners as well as the respondents are concerned with, the convenience of general public. There is no other convenience that we are talking. So what balance are they actually trying to rely on? Also, they have said that violation of Hamsa Act was being done, have evidently proved that how it is excluded from the definition. Legality of construction, they have opposed the legality of construction but have failed to prove how it is illegal. They have again not proven how religious sentiment is being a part of essential religious practice. They have said that it would be irreparable injury if the status quo order is vacated, Your Lordship. However, they do not show that how are we interfering with general public, what have we done which would cause an irreparable injury. We also would like to say that they had, when they were talking about the FIR being filed, they talked that the state has undertaken, they had filed this FIR on the first place as an act of vengeance, as an act of revenge. But they have been, they were silent on a substantial material fact that this was not after the status quo. Must notice that when the construction was first started, even before PIL and FIR, the process turned violent, and we had to engage police so that the construction activity is undertaken. So it was not the first time that we had filed a FIR against them. It was the second time that they were doing that we were bound to file an FIR against the general public. Much obliged, Your Lordship. This is all we have to say in the rest.
Okay. Thank you. Thank you. I must, before we go ahead to the result, I must say whether A wins or B, it was a pleasure to hearing both the sides. And even if it is and one person gets a few marks more, I must say the events are very well balanced, and you all were outstanding. Both of you, all three of you were outstanding. And I feel that there should have been some teachers, because I wanted to compliment them. I've never seen. I've been in in Delhi University also in the Law Act. But I must say that you're an outstanding. And you are as good, if not better than them. And then I want to say a few things about the gentleman in whose name this Moot is being conducted. He was a very dear friend of mine, never took him as anything than a younger brother. He was amazing as a counsel, who was very thoroughly prepared. And both of you have very demonstratively followed that footstep, which is the imperative part of being a good lawyer. The fundamental of being a good lawyer is the three things, the fundamental of a good lawyer. Perseverance, perseverance, perseverance. It's never brilliance. Brilliance comes later. If you persevere, you get all the brilliance, the articulation and everything. So you have to persevere in a manner that will keep you focused. Our profession is one of the finest profession and enigmatic profession. So much to it. You can do good, and there are innumerable avenues which have opened up. PIN was one such avenue which was borrowed from the English and American courts and brought into our fold. And this has done great job. So therefore, I am really surprised that for myself I can speak that I probably didn't know the law as well on these subjects as I was enlightened by both of you. I must hasten to add, I have a matter in Supreme Court on Monday pertaining to a temple, which I will definitely remember all these things that both of you have argued. I am very, very, very impressed. And I wish you all the best in life. And I would have appreciated if some teachers were there, because this is a place where I started. And this is the place which I've admired. And now I admire more the constituents than the buildings. Thank you ever so much. And I have to excuse myself because I have a flight to catch. I may miss it. I leave it to my learned friends to continue. I'll be deeply obliged if I can be excused. If I get stuck in the traffic. Bye-bye. But hey, bye. Pero habíamos querido. Back into the
इनके ऊपर से करीब की नहीं आएगा।
अगर नहीं की सकता हमारे
Then another, no, Mr. you know, with that, and finally, and fact that the review is conducted like 20 young content talk with the not it's funny exactly funny.
Seven, in all two football competitions that was only confined to the politics. And today we are glad to see that the football competition of such a vast magnitude that taking place. And lots of students were aspiring to be lawyers, to be leaders, to be corporate sector, and also to be leaders in the infrastructure. And they have been participating in football competitions abundantly. It's a very good sign. And with all the three judges that have been assigned with them, the duty to find out who the winner is. We are extremely satisfied by discussing amongst ourselves and to how good the performance of both the teams is today. And I think that my friends just by that like they were discussing what told me that you cannot the legal world is so bright in our state that we can, I mean, no longer the clients from outside would be hiring the services of lawyers from outside. When we joined the legal profession, mostly were finding the important matters. Lawyers, I think, in Kolkata or Delhi, where arguing matters, of course, that was the advantages for us. Today, if you come to the High Court or any other court in the state of Odisha, you will find the number of foreigners who are court is very less. And Odisha is proud of its indigenous products of lawyers. And you younger lawyers would definitely carry forward the legacy that we are sitting in. We can say, myself, Mr. Mukherjee, Mr. Ram, we can say that we have put in a value and obstacle from the foreigners to come to our place. And we could prove that we are progressing. And now you, the younger generation, at a very national group, have proved that you are much, much higher than what we are. Such a great and proud moment for us. And again, time is running again for the declaration of the announcement of the result. But before that, we would like to see the pulse of the teams. So why you are not so aggressive that they are lots of aggression, yes. And in fact, both of you are and the third person is missing. So that is the reason the third person is missing. That is no third person at all. So you have two people against three. Right? So they have one additional batsman with them. So your team is without a bowler, without a fielder, and without a batsman. Right. But umpires will not take any side. If 300 doesn't matter, for umpires it is all 300. No. by looking at the composition of the team and then you want to see what but Supreme Court now, of course, for a couple of years, that's when you get second. There are some single benches are now available in Supreme Court. This happened only a couple of years back. But earlier to that, Supreme Court is to see the division bench according to Constitution. The division bench was comprised of 2 judges or 3 judges. So that is judgment of 1985, KIIT 1985 Supreme Court. Where Supreme Court has said, Honorable Supreme Court has said, a division bench of 2 or 3, then political bench. So 3 judges cannot say that they are superior to the bench. But there are instances where the 3 judges is superior. The instances like a human instruction. Suppose there is a difference of opinion of a political bench comprising of 2 judges. Then the matter is referred to the 3 judge bench. When the matter is referred to a 3 judge bench, there 3 judge bench is a verdict. Then that has a better value than the 2 judge bench. Otherwise, 2 or 3 are said for you to have. What do I say? What would we say? You have to be very confident. Right? Very difficult to pierce through. And whenever some doubts were making it, or we are doubts were generating in us. In fact, I was thinking twice or thrice. The way they are speaking, the way you are presenting ourselves. So in fact, ask for something. That's the same shows how good you are. The same point of time. No, if the small gun is very small, it's like a pocket size, I don't know. All right. So she can explore at point of time. The dino has also explored. But they have a desire to combat that, counter that. So now let us see who comes out. Right? Again, pulse. You want to think of the pulse. So no more suspense. And the winner is who? Tell us, who? Well, so no more insights. Getting to down. The runner-up team is AKN28. MS Club in the securing 463 and congratulations. So well done. And you know, you have not failed. You have succeeded to come out in this battle as runner-up. Keep one thing in mind. In the legal profession, there is no failure. You have to take away the word failure from the dictionary. Right? It's an experience. So this is an experience of being a runner-up in such a, what do I say? Such a big event. To be a runner-up in such a big event is an achievement. Keep it up. And the order is quite obvious. The compensation dynamo and the name 8827 17 KIIT University. Which has 527 marks. And there's an announcement. Before the announcement, I would like to say one thing. Whenever this is a moot law, I would say like it's a prelude to enter into the legal profession. So every aspiring to be a lawyer has to bear in mind when you are arguing a matter in the court, it's not a classroom. When a judge puts something, nobody should take it as if it's a question to judge side. The moment you take it as a question to judge side, you must be backward. You should always think that you are the master of man. And you are also master of the law. The aspect which you are going to put across to the bench. The bench has some doubt. Right? But doubt in the mind of the bench, they are expressing to you, please clarify this. So when something falls from the bench itself, you should always think that it is a doubt that has crept into the mind of the judges, then want the clarification. If you take it in this way, then you will be getting doubly motivated to answer the question or answer to the clarification with double vigor. Then you will succeed. Right? Don't at all get bogged down to a question if I don't put to you at the moment. Right? And all this time to help the lawyer friend, and just telling a few weeks back, I was confronted with a legal proposition. Incidentally, 7 years back, I was sitting in Chief Justice Court. My friend Mr. Mohapatra was arguing a matter of exactly similar nature. I got an order. So I was searching for Mr. Mohapatra. How to get that decision from him? When getting to the court, I said, welcome, I have a test that I will go to. Then I told him, this is what I want. He just told me, just remind me in the evening. He calls me my dignity was most valuable. Like what happened? I call him in the evening. Within 2 minutes, he calls me back. You spend seconds. That has to be the approach of every legal, every individual in the legal career. Right? So now the announcement. There will be a paid internship for 2 months under the Department of Women and Child Welfare, the government of Odisha, to the best mooter and the best researcher. So the best mooter of this event and the best researcher of this event would be getting a paid internship for 2 months under the Department of Women and Child Welfare, government of Odisha. Such a wonderful offer. And again, congratulations to the best mooter and best researcher, they were asked about. And this is the stepping stone for all of you. And keep this zeal. Right? This zeal should never, in fact, fall down. You have to go up and up. Thank you.
Inspirational words to all the students, and thank you everyone for your guest presence over here. And I especially thank to the volunteers present over here for their great effort and cooperation. I hope you will be doing more moods, and we are waiting for you in this profession in future. Thank you.